morning, everybody, and welcome to Law and Crime, where we cover some of the most interesting live trials and legal stories in the news today. I'm Jesse Weber, joined by trial attorney Brad Micklin. We have a lot to cover today, multiple live trials and things to talk about, so let's get started right now. First up, I want to let everybody know that we are carefully monitoring the feed in the Claudia Herrig case out of Ohio. We expect to be live in this courtroom at around 9 a.m. Eastern Standard Time, keeping an eye on it. And again, this is a really interesting one to follow. She is charged with the murder of her husband, Air Force Reserve Major Carl Herrig, which happened back in March of 2007. It's alleged that she shot him multiple times and then fled to her native Brazil. And then this is where things take an interesting turn. It took authorities 10 years to get her extradited back to the United States, and now she is facing her trial. What we saw yesterday was about 2.5 hours of her interrogation tape, where she just went flat out and explained what happened, why she shot this man. The defense is not arguing that she shot him. They're just saying, why did she shoot him? Probably an attempt to lower the charge. Remember, she is charged with premeditated first-degree murder, prior calculation, and the defense seems to be trying to battle that down a little bit. So again, we expect the live feed in that courtroom in any minute, and as soon as we have it, we'll make sure to go there. I do want to also let you know that we are in verdict watch right now in the Jeremiah Monell case out of New Jersey. A jury will have to decide whether or not they will find this man guilty of killing his wife, Tara O'Shea Watson, by allegedly stabbing her to death multiple times. Prosecutors say at least 48 times. And in one of the most tragic aspects of this case, the couple's 12-year-old son, or then 12-year-old son, discovered the body of his mother. He was right there when this killing took place. The question is, will the jury find him guilty? Now, they deliberated a little bit yesterday. They actually asked for a little bit of trial transcript, and then they will eventually begin their deliberations again today. So again, we could get a verdict any second in that trial. We'll let you know if we have an update as well. I also want to let you know that, we've been following the Charles Merritt case out of California, the man who's been charged with brutally killing an entire family and burying their bodies in the Mojave Desert back in 2010. Their bodies were discovered in 2013. Well, court is dark today. It's dark on Fridays. They'll be back next week. We expect Tuesday to resume trial feed in that courtroom. If we should get an update and anything to happen in that case, of course, we will let you know. Now, we have some exciting things to tell you about what's on the program today as well. At around noon, we expect to hear the sentence in the Jason Van Dyke case. You remember the officer who was found guilty of second-degree murder and 16 counts of aggravated battery in connection with the shooting death of Laquan McDonald back in Chicago, Illinois? Well, that officer has yet to be sentenced. Former officer has yet to be sentenced, and we believe he will be sentenced at around 12 p.m. It's a question of what will he face. He faces different prison time based on the second-degree murder charge and the aggravated battery charge. And it's also a question his defense team wants to even ask for probation, or at the very least, if not probation, 6 years in prison. But he could be facing 20 years, if not more years in prison. There's a lot to talk about here, and we are going to focus more on it. I do want to let you know about one thing that you may have missed as well from yesterday. Speaking of Mr. Van Dyke, 3 officers faced obstruction of justice, conspiracy, and official misconduct charges in relation to this shooting. They were charged with trying to cover up the details of this shooting in order to protect their fellow officer, Jason Van Dyke. This was a bench trial. A judge had to decide the fate of these men, and yesterday we heard the verdict. If you haven't seen it, let's play it for you right now.
Van Dyke.
Okay, with the judge poking holes in the prosecution's case and showing that they're where the weaknesses are, what was the ultimate verdict? Let's play that for you right now.
Relevant. Conclusion. The crux of this case rises and falls on whether the information that the officers, including March, put in their reports or told the March was false, and if so, was it done to prevent Van Dyke from further investigation or prosecution? For the reasons stated above, this court finds that the state has failed to meet its burden on all charges. Therefore, there is a finding of not guilty as to every count and each defendant of conspiracy, official misconduct, and obstruction of justice.
And there you have it. They were found not guilty, all three, of obstruction of justice, conspiracy, and official misconduct. Let's talk about this now with trial attorney Brad Micklin. Brad, were you surprised by this verdict?
No, I was surprised that they even brought the charges in the first place. You know, police put their lives on the line every day. Their job is to uphold the law. But also the prosecutor's office, they work together with the police in prosecuting crimes. So they're part of a system. So to bring these charges in the first place with so little evidence was actually surprising.
They said, look, she said some of this it's speculation to know what was going on in the mind of the officers. One word, the fact that they included the word lunge when clearly there was no lunging, but in a police report is just not enough. It's insufficient. Is it that the prosecution didn't have enough evidence? Is it that they didn't argue it properly? What do you think?
I don't think there was enough evidence. I mean, again, you know, one word in a situation like this where it's so traumatic and so frightening, even to a police officer, a shooting, the recollections are always going to be different, the information they have. But here they needed to prove that there was a conspiracy to cover up something that was done with all three of these people, and that would have been difficult, even if there was a lot more evidence.
You can imagine people are watching this verdict and they're unhappy with it because they were looking at this to find police corruption, a police cover-up. Do you think there was any pressure on the part of the judge to rule a certain way?
I don't think there's pressure on the judge to rule. I think there was pressure maybe to bring the case in the first place because there's always a lot of speculation about police misconduct and cover-ups, and it goes, you know, decades back when it comes to televised criminal trials like this. But I don't think there was any pressure on the judge to find a certain way.
You know, people could look at this and say, well, if they got off, then how come Van Dyke was found guilty?
It's an entirely different crime. I mean, Van Dyke had a very long trial, but you know, he shot 16 times, and there was video for all that. You know, here I think just the opposite. You know, we forget that most of what's going to be done between any individual is going to be documented. We don't do things on the telephone anymore. We do text messages, emails. Everything is video or audio.
It's not always good. Not always good. It ends up in a courtroom.
Right, but it helps in a courtroom.
That's exactly right. And you know what? It's interesting we got the verdict yesterday because today at 12 p.m. we are going to get the sentencing in the Van Dyke case. That's just one of many things that we're covering here on the network. We have to take a quick break, but we'll be right back, so stay tuned here on Law&Crime. Okay, well, that's defense attorney Nathan Perry, who's saying the state just hasn't met their burden to prove that Jeremiah Monell is the actual killer. Let's continue on with the defense's closing argument from yesterday.
Again, the bits of the puzzle simply don't fit one another. And it's the state's obligation to prove to you each and every element of every charged offense beyond a reasonable doubt. Now, what's reasonable doubt? I'll tell you a little story. 2010, I was courting my wife to be, who would become my wife. She had two lovely daughters. I was game to impress her. Near Christmas time, I bought all of us tickets to The Lion King on Broadway. And I'm all excited to leave it. And we get up and load up the car. We're doing 175 down the Parkway. I probably get into Ocean County, and I'm gripped with fear, terrified. Pull off the Parkway onto the grass, get out of the car and rifling through my pockets. Did I forget the tickets on the counter? That was a reasonable doubt. That's what the state has to do. They have to prove each and every element of the offense that's charged against Jeremiah Monell beyond a reasonable doubt. And if they get you there, and I don't think they do, they still have to go a step further.
Okay, let's break this down right now. Now, Brad, we're waiting for the verdict in this case. We're trying to hear what the defense argued. They really didn't put on a big case. They've had one witness testify. And what they're basically saying, if I heard it correctly, is the prosecution didn't put on enough evidence. They didn't meet their burden. And the first thing they said was, if you look at Jeremiah Monell Jr., the most, remarkable witness we've seen here, can you really question his credibility? I mean, it was dark in the trailer. He had an obstructed view. What did he see? What did he not see? What did we hear from him? Is that effective?
No. I mean, when you have a witness that's credible, like a child and a relative, his son, few people are going to disregard what he has to say. But the problem with this case is you can only argue so many things in a murder like this. You either argue, I didn't do it, I was insane, or I was in the heat of passion. None of those fit, because heat of passion, if you stab somebody 48 times, the passion is long gone, so that's not justified. If you say, it wasn't me, you have to discredit the witness. Or, I'm insane, and then you need some medical evidence, and you have to be willing to do that.
What about self-defense? Because what the defense said was, what happened before the killing? Maybe there was a fight. I don't know, but he said, did Jeremiah Monell actually act in self-defense? I don't know. Those are questions that are left open for you to answer. Is that the correct legal framework?
I don't think for reasonable doubt. Self-defense might be a good defense, but not when you stab 48 times. Just like with the Van Dyke hearing, which is unrelated, but he shot Laquan 16 times, and I think the jury says after a certain amount of times it's unjustified. And 48 is just, it's exhausting if you have to stab somebody, I would imagine, 48 times.
And the knife was bent. I mean, look at that. What a really heinous attack. But the question is, did the defense raise some questions in the minds of the jurors? We're going to have to wait and see what ultimately happens. Let's take a break. When we come back, we clearly have a lot to talk about on the network today, so stay tuned. We'll be right back. Okay, so Brad, this is interesting. They're basically saying that the defense's argument, raising theories, is speculation, that the defense needed to show some evidence to prove their theories. Is that accurate? Because even if the burden is on the state, does the defense need to prove some evidence that there was some fight ensuing, that maybe it was a third party, or do they just have to question the credibility and the evidence of the prosecution?
Technically, neither. I mean, it's the state's burden to prove beyond a reasonable doubt. Because remember, everybody gets tripped up on that term. It's not just we have to prove it, we have to prove beyond a reasonable doubt. Defense doesn't have to put on any case whatsoever.
So is this accurate, what the prosecution's saying, to criticizing the defense's closing argument?
No, I don't think so. I think, and I'm not even sure why the prosecution would do this, because I don't think they even needed to attack the defense closing argument. I think they should have just stuck on point to their case and the obvious facts of it.
Yeah, well, it's interesting to see. I want to continue on with the prosecution's closing argument. And one, before we do, just real quick, why did the defense go first? I've never seen that happen before. And you said to me in the break, that's not a great strategic move.
No, I've never seen it before. I think it's a horrible move. Unless you have a closing argument where you can so clearly say that everything the prosecution is going to say is not established, everything is clearly in favor of reasonable doubt, is the only reason you would go first. If you clearly negate what they're going to say. Otherwise, you want to be the last one heard. You want to be able to get up there, wave your arms, and bang on the table and say he didn't do it, there's no proof. And have that be the last thing that the jury hears.
But the last thing the jury hears is the prosecution's closing argument, so let's continue on with that from yesterday.
Think about the timing leading up to what happened to her. Think about what Jeremiah said about the course of actions that took place inside that house before this happened to her. The opportunities for the actor to cool down, to deliberate, to think. The 89 stab wounds described by Dr. Matone and sharp force injury wounds described by her. Defense wants you to draw an inference that that's evidence of passion. I would suggest to you it's evidence of a person's depravity, of their state of mind, of a vile and horrible and inhuman action. That it's evidence of torture, that it's evidence of an aggravated assault. That's what it's evidence of. The judge will also tell you that words alone, words by themselves, cannot constitute provocation. That there has to be something else that goes along with that in order for somebody to have some kind of reaction, a knee-jerk reaction. But the evidence here shows that this did not happen in the moment of something. This didn't happen all of a sudden. The evidence shows that there was a plan, that there was a calculation. There was deliberation on the part of the defendant. The purpose of the defendant's actions here are clear: to cause death. It's not as though his actions were reckless. It's not as though that there was some kind of indifference to what would happen. It's not as though he didn't care what would happen. 89 sharp force injury wounds, a slash to the throat. That's purpose, pure and simple. That's murder, pure and simple.
Okay, that was the prosecution's closing argument in the Jeremiah Monell case. We're waiting for the verdict. We're in verdict watch right now. And let me see if I get this straight, Brad. If the jury comes back with a verdict of not guilty, or if there's a mistrial, so they couldn't decide it one way or another, does that mean that they just didn't believe Jeremiah Monell Jr.?
It would have to be, because it's so clear what happened here. And there are few people that a jury would reasonably would commit this kind of a crime, this heinous crime, 48 stabs. You're not just going to have somebody usually that comes off the street and stabs somebody like that. So the only reason would be that, or they get hung up on the beyond reasonable doubt, and they don't want to sentence a man to prison based on a child's statement. That's the only thing I can think of.
But the defense was careful not to criticize Jeremiah Monell Jr., but to say, hey, listen, his view might have been obstructed, it was dark, not questioning his motivation in testifying, but whether or not what he actually saw. That was strategic, wasn't it?
Of course, because it's hard to criticize or cross-examine a child, and people aren't going to believe the child is coming up with any other motive, especially if he's testifying against his own parent. So you have to walk gently when you're talking about a witness like that.
What about the fact the defendant didn't testify? What did you make of that?
That's not unusual. It's always risky to have a defendant testify, especially in a case like this, because the acts are so bad that you have to imagine, if he did commit it, that he's not sane and he's not going to be a good witness. So putting him, no, I think he needed to testify here to say I didn't do. Yeah, because the jury's going to conclude that with the son's testimony and the heinous nature of the crime, that it had to be the husband. So the only way to negate that is to get up there and say it wasn't me and give some kind of alibi. It
would have been weird for him to testify and contradict his son. You know, very strange to see that dynamic to play. Maybe he didn't want to do that.
I mean, if he let his, assuming he did this, if he let his son witness it, I don't think he has that much concern for him, and he's on trial for his life. So the jury's going to wonder if the son's testifying, why isn't the father correcting him?
And he was offered a 30-year plea deal and rejected it, and was forced to, and now took this trial, and you could say, or forced his son to testify against him.
And passing up a plea like that, it shows he's insane, because the evidence is so bad against him. And if anybody knows, if your son's getting up to say he did it, it's not going to be easy to walk away from that.
I mean, I just don't understand the dynamics. We look at the feed of Jeremiah Monell, the defendant, trying to get a grasp on what's he feeling. He seems almost emotionless throughout the whole.
It's strange because, the defendants usually, when you get up here and you see them on the stand or you see their mug shots, they have a certain appearance that justifies the actions that you think they committed. And here he looks like a normal, average guy sitting calmly, waiting to be sentenced, to prison for killing his wife. It's strange.
But no emotion when his son's on the stand. No emotion when they're talking about the wounds sustained by his wife. I mean, how do you reconcile that?
He's a psychopath. Because most people are going to be emotional, whether you're emotional because you're worried that you're going to go to prison forever, or you're emotional that your wife was murdered. You're going to have some kind of emotion. The only other reason would be if your lawyer said, don't react like that, stay calm. But that would never be advice that would be given.
And you look at the defendant and you think to yourself, okay, it's never easy for a jury to decide a person's fate no matter any kind of trial, correct?
Yeah, I mean, the jury's sitting there. They have ideas in their head about reasonable doubt. They have images from the media and TV and movies, but they're putting somebody's life on the line, and they want to be certain that when they go home, they did the right thing.
Yeah. Well, we are in verdict watch in that case, and we're also carefully monitoring the Claudia Herrig trial as well. Hopefully, we'll be live there any minute. So I'll tell you what, let's take a quick break. We'll be right back. So we have an update for you in the Jamie Kloss saga. You remember this 13-year-old girl who was kidnapped and then found 3 months later on January 10th. Her parents were killed and she was taken. Jake Patterson has been charged in connection with this home invasion and kidnapping. In fact, he's been charged with 2 counts of first-degree intentional homicide, both punishable by life in prison, 1 count of kidnapping and 1 count of armed burglary. Well, we've just learned that the authorities have found a job application that this man submitted, which is a very interesting thing because on the application, he calls himself an honest guy, a hardworking person, but his resume contains several inaccuracies, including his service in the military. We're learning more details about this, and I'm back here with trial attorney Brad Micklin. Every detail about this case is pretty fascinating to study, but here's a guy who goes on a resume, puts on his resume that, he's a pretty good guy, when in reality, he's just been charged with heinous crimes. This is, the details just can't be made up.
But who's going to tell the truth on the resume to begin with? It has nothing to do with whether or not he killed this girl's parents and kidnapped her. And maybe he didn't serve in the military, so he just flat out lied. But that has nothing to do with how heinous of a crime he may have committed.
Yes, defense attorneys haven't responded, in terms of a request to confirm the resume. I guess that's a smart move. It really doesn't play into the case. But it does give you an insight into who this person is.
It could. There might be more details. I guess in hindsight, I have to stop and say, well, if they released this, there had to be a reason. It had to be more compelling than just he lied on his resume. So maybe there's some more details that I was just not familiar with yet.
It's a fascinating case, and of course, as soon as we have more updates in it, we'll always let you know. It's something that's an ongoing saga, and who knows, maybe we'll cover his trial if there is a trial here on Law and Crime. But let's talk about one of our trials that we are covering currently on the network, and we're waiting to go live in the Claudia Herrig case out of Ohio. Now, we saw the testimony yesterday of Andrew Chappell, who's a firearm examiner. Remember, she has been charged with shooting her husband multiple times, 3 times, twice in the back of the neck, once in the head, back in 2007. It's alleged that she bought a .357 Magnum revolver several days before she ultimately gunned him down. She had target practice with it. She knew what she was doing. Very powerful weapon. Let's learn a little bit more from the fire examiner whether or not the shots sustained, the wounds sustained by the victim come from this gun. Take a look.
And what determination did you make regarding those items?
That the 5 fired cartridge cases were all fired in the submitted revolver.
Okay. And then you went ahead and I believe you looked at the projectiles and the fragments that were marked as 3A, 3B, and 3C. Is that correct?
Yes.
And what did you do with those, and what comparison did you make?
I first examined each of the bullets and fragments, taking note of their characteristics, and then compared those to the test fires that I had generated from the submitted firearm.
And with respect to the projectile number, it's our State's Exhibit 4, was a projectile under the body. Did you make a comparison of that item?
Yes, I did.
And finally, State's Exhibit 5, the projectile fragment from the basement. Did you make a comparison to that item?
Yes, I did.
Okay. And can you please relate to this jury the findings that you found between State's Exhibits 1, 1A, 1B, 2, 3A, 3B, 3C, 4, 5, and then 6A, B, C, D, E, and F?
Of the fired bullets and fragments, there were 2 recovered from the body, 1 from underneath the body, and 1 from the basement that all had matching barrel engraved striations with the test fires I generated using the submitted pistol. And that means that those were fired from that revolver. The remaining fragments did not have markings suitable for comparison, and so I wasn't able to.
All right, that was some testimony from yesterday where the prosecution is establishing their case. Now, I'm getting word we are live right now in the Claudia Herrig case. First witness of the day. Let's go live right now in that Ohio courtroom.
ECI did it for your office.
Okay. But it's recent?
Yes.
Okay. And it supplemented a prior transcript that we used in proceedings in this case before.
That's correct.
And when you identified 91, would you look at that again?
Yes. 91 is the transcript from the enhanced DVD, and that was done by court reporter Kelly Haas from Gerard Court.
Okay.
And that was done really recently, within the last few weeks.
Okay. So in order to make it sound more clear and bring out words, an enhancement was done.
That's correct.
And did you go over the enhanced version video and the transcript?
The enhanced version of the video
and this transcript,
yes,
91.
Yes, I did.
And you testified that it accurately and fully portrays what's on this.
Yes, I said there's a couple inaudibles in there. There's a couple times where she uses U.S. Marshal Bolden's name instead of mine, or vice versa when one of us is talking. But all in all, it's very accurate.
And you testified that the nearly 2.5-hour presentation to the jury yesterday was accurate and complete.
Yes.
And to the best of your knowledge, save and except for that, you were satisfied that these two matched?
Yes.
Okay. Now, when this case began, relative to taking a statement from the defendant, you also testified that you took a video recorded statement, which enhances is 74, during that January 17th and January 18th interrogation at Trumbull County Jail in 2018, correct?
Yes.
How is that video system?
Okay, testimony has resumed for the day. We'll jump back into that in a minute. Brad, I got to tell you, the confession from yesterday, or this alleged confession, was really something to witness. That can't help her case at all, can it?
No, well, no, it never helps. I mean, the only thing it gives her maybe is credibility to her story, that she's not hiding behind a reasonable doubt, that she's not refusing to testify. But it's never going to be helpful. She shot him in the back 2 or 3 times.
And the defense is not arguing that. They're just saying, why did this happen? Let's look at the relationship. Let's try to see what happened that day. But this is not a pre-planned murder. Let's take a quick break. When we come back, we'll be live in that courtroom. Stay tuned here on Law and Crime. So this may all be about the specifics of the tape and whether anything was altered, was the transcript was altered, but I really want to talk about the context of the tape right now. She provided statements without even being prompted. They were told not to Mirandize or to question her on the plane, and she just kept talking and talking. And then in this recorded interrogation tape, she continues to talk. What do you think was going on in her mind?
I always have problems trying to determine what goes on in the minds of a person who admits that they killed another person. So it's hard to say, does it make sense? Is it reasonable? Because she probably wouldn't have done it in the first place. And maybe she was living with it for so long and she felt it was safe that she just needed to get something off her chest.
Interesting. She said, I don't want to be, I want to be fair to the family, but I don't want to be unfair to myself. If I say only a few things and I don't say the whole thing. And then she goes into the fact, which I thought was interesting, that there were 5 bullets in the gun. She knew she shot 3. Then she tried to kill herself, but the gun didn't work. Did you get that flavor of the transcript as well?
I didn't get it from the transcript. That's the nature of her case. Her defense is that it all started that she intended to kill herself first, and then it turned into this heat of passion killing. So that would be consistent with the defense.
If the jury believes that she made the statement, if this is the statement that she allegedly made, if my husband didn't tell me to go to the basement to shoot myself, he would still be alive, I would be dead. What do you think of that statement?
I think it's ludicrous. I mean, I'm not a big fan of this defense to begin with. She shot him in the back, and her claim is, I was going to kill myself, but because he was so mean, I killed him instead. She could have killed herself first. She could have killed herself afterwards. It's just not believable.
But what the defense did kind of, maybe a good strategy yesterday, is they questioned the reconstruction expert about where the bullets were fired, the trajectory of the bullets. And I was curious, does that at least help establish that maybe there are 2 ways to look at this shooting and it's not a clear-cut cold-blooded murder. Maybe it was more self-defense, if that's the way to explain it.
It's hard to say because she shot him in the back, but you could argue he was fleeing and she killed him, or he was leaving and she got so upset that she shot him.
Okay, well, we'll have to see. And not self-defense, so much more heat of passion. Let's take a quick break. When we get back, we'll cover more of this exciting trial out of Ohio. Stay tuned. Okay, let's break this down right now. Brad, what are you getting from this line of questioning of this witness?
You know, the fascinating thing about the case in this testimony is everything that she did is either premeditated and she murdered him, or heat of passion and she accidentally or unintentionally killed him. So she wired $9,000 to her family, either because she wanted them to have it because she was going to kill herself, or she knew she was fleeing to Brazil and needed the money. She researched suicide, so either she planned to kill herself, or she planned to make the crime scene look like he killed himself.
It was interesting when you read about it or listened to it, and where the idea that, hey, she wanted to go to Brazil to say goodbye to her family because she thought she wanted to kill herself. Well, if that's a possibility and she went there and then they convinced her not to kill herself or not to give up life, is that a possibility in the way that her story still may be true and that changes the jury's verdict?
I don't think so. I think if anything, if they convinced her not to kill herself, it still doesn't justify what she did in this scene. I don't think that shooting her husband in the back is ever going to be justified.
So the idea of like the fact that she wanted to kill herself after this, that doesn't really play into the jury's verdict?
I don't think so.
It's interesting because trying to make details of what happened here is very interesting. And the idea that she only went to Brazil because her family, after telling her, she confessed to what she did. They told her, get on a plane, come to Brazil. They even had a lawyer on the phone. That's different than her planning it for months and getting tickets ready and doing like that. I mean, she did buy the gun, but that does play a different aspect, doesn't it?
It does, but I think there's also some talk or speculation that maybe she returned because she was unable to remain there, that she did something to jeopardize her citizenship. So it wasn't necessarily that she was coming back to face the music.
A lot of moving parts in this trial, I'll tell you that much. Let's take a quick break. When we come back, we'll be live in the courtroom. Okay, so Brad, what are we learning from this line of testimony? What does the defense really want to point out here?
I think both sides, the prosecutor and the defense, are trying to show, obviously the prosecutor is trying to show that he was putting on his shoes, so it wasn't a heat of passion. I think the defense is trying to show just the opposite, that he wasn't doing that, so it could have been the heat of passion. I don't think it helps because a heat of passion doesn't have to be limited to the exact moment. It can be an extended period of time, which makes it more difficult to sell that to the jury, but it doesn't have to be that she shot him right after he said, go to the basement.
In other words, what you're saying is they're raising good reasonable doubt right here about what really happened, because there's only two people that really know what happened in that day.
I think so. I mean, it's clear that obviously she admits she killed him, and she killed him from shooting in the back. And the statement she makes would turn anybody's stomach, that the husband said, if you're going to kill yourself, go in the basement. But it's still a question of, did she buy the gun in advance and I think put the laser scope onto it to kill him, or was it heat of passion she grabbed it? That's just not believable.
And it's also a question of whether or not he even made that statement. The prosecution says that that's not what happened, not consistent with this narrative. What the interesting thing to note is, on her flight back from Brazil, she just kept opening her mouth and talking a lot about what happened. I think we can go back live into the courtroom. I just want to confirm that, okay, no, not yet. They're still waiting to hear what's going back and forth. I got to tell you, the prosecution and the defense in this case, the back and forth between them is so heated. I'm sure you've seen that in your experience as well.
Well, especially with a case like this, because again, every single fact that's relevant could be premeditated or could be heat of passion.
Yeah, and you're definitely seeing it. Okay, let's go back live right now. Again, this is the Claudia Herrig case. You know, Brad, I don't like to say I'm right, but again, nobody knows what happened in that apartment, in that house. I mean, again, it's the same thing as what he just said, right?
Yeah, and I think the back and forth was just wasteful. You know, lawyers always like to have the last word, but the prosecutor should have never got back up to recross, because now it's putting on the shoe as a bigger issue than it really was. If he would have just let it go, the jury probably wouldn't think twice of it.
I got to say, here on Law&Crime, we always wait to see if the defendant will take the stand, and we believe she will in this case. She's been very vocal before, very vocal in that jail, talking about her conditions. What would you expect for her to be like on the stand?
It's hard to say. I mean, I think she has to take the stand because I think her attorney in the opening said that she was going to, so the jury's going to be waiting for it. But it's hard to say because we don't know what kind of a person she is, what kind of witness she's going to be. She could be great and calm and cool and really well-versed, or she could be crazy and seal her own fate.
Well, she's already been complaining in jail about the living conditions. She says everyone's out to get her. She's been complaining about the American justice system, about her extradition. Does that give you any insight into what she would be like on a stand in front of the jury? And you know what, the world as well, because everybody's watching this. We're broadcasting it.
Right. The worst thing about a witness like this, she talks too much. If you're a criminal defendant on a murder trial, you want to say the right thing and concisely. If she's been talking and over, she's going to probably do the same on the stand, and it's just not going to be good for her.
In other words, when you're a witness on the stand, just answer the questions that are directed to you, no other details.
Right, because you never know what the jury's going to focus on, and everybody gets into their head thinking how something sounds, and it's usually a mistake.
Yeah, so people are their own worst enemies. Let's take a quick break. When we come back, we have a lot more to discuss, and we'll be live in the Claudia Herrig trial. Okay, I'm back here with trial attorney Brad Micklin. Interesting witness recounting what apparently Claudia Herrig had said. An interesting comment. If she said, if she ever left me, I'd kill him. And Claudia wasn't laughing about that comment.
Yeah. I mean, it's not unusual. I mean, people will say that all the time. But most people will say it to their partner or their friend. She said this to his friend. And that does suggest a little more meaningful, because you don't go out to strangers and tell them this.
But you never want to convict somebody based upon comments, right?
Not especially this. I mean, it was 11 years earlier, and not everybody, but many people say things like this. You can't really judge somebody's actions because they said something like that years later that something happened.
Brad, isn't it remarkable that we're even in this trial? I mean, she could have lived out the rest of her life in Brazil if it wasn't for the efforts of authorities and lawyers here in the United States, because she was a Brazilian national. But they were able to provide enough support or evidence, correct me if I'm wrong, that she renounced that citizenship.
Yeah, I mean, it's challenging. Extradition is always difficult. And look at the years that it took to do this and the cost that we incurred as a society, or this, Ohio as a state, to have to prosecute this crime. It's unfair that it could be done so easily. But at least it's, justice is playing its part now.
But isn't that also because of who the victim is? You have somebody who was in the military, and that was a reason why it got so much attention?
It might be. I mean, obviously, certain people get elevated status when it comes to commission of crimes, like police officers, military. But hopefully it's just because somebody's life was taken, and they should be prosecuting everybody for it.
Yeah, I agree. I think what we can do as we wait to go back, I think they might have taken a little break, we had a testimony yesterday of a U.S. Marshal who was on that extradition flight with Claudia, and his testimony was something to really listen to. Take a look.
You take custody of Claudia Herrig
on January 17th of 2018.
January 17th?
Yes.
And where would that be?
That was at the international airport in Brasilia, Brazil.
And what authority did you deal with in Brasilia to obtain custody?
We took custody of her from the Brazilian Federal Police.
And what time was that exchange?
I don't recall the exact time. We arrived at the airport approximately noon to 1 p.m., but there were some delays.
And did you have a female officer with you?
Yes. So we had a team of officers with us. When we arrived at the airport, it was myself and a female special agent, Angela Brenner from the U.S. State Department. She and I actually went into the room and took custody of Ms. Herrig from the Brazilian police.
And how was the reaction when that took place, if any?
She seemed very surprised, kind of stunned to see us. She knew she had gotten moved from where she was.
Your Honor, objection, relevance, as to what she knew. You guys know what she knew. Except for what she knew. Go ahead. Okay.
So, I mean, you're going to take somebody you never saw. Do you see the person you took into custody here?
Yes, I do.
And would you point her out, please?
She's seated at the defense table.
And may the record reflect she has pointed out the defendant?
This witness is identified.
And during the flight, was there a time that Claudia Herrig said anything to you?
Yes.
And in your own words, beginning to end, tell the jury what was said by her and you in that exchange.
Initially, during the boarding of the plane and the initial part of the flight, we engaged in general conversations. Life in Brazil compared to life in the United States, the conditions of the prison or jail in Brazil, number of just general topics. At one point during the flight, she made the comment, "A wife does not kill her husband without a good reason." That might not be the exact quote, but something almost like that. I was a bit surprised. Myself and Agent Sano, Special Agent Sano, were sitting across from each other in the aisle. We both looked at each other. It was obvious we both heard the comment that she made. And then the conversation just continued from there.
I guess a lot of our viewers are asking the same question, Brad. Why would she say anything when she's arrested?
Again, she might not have known that she shouldn't. She might have been unable to control herself. She could have lowered her guard because, as this witness said, there was some banter going back and forth. I just think that she couldn't live with the guilt, but she didn't know better than to not say things that would incriminate her the way they have.
Let's break this down. If, in fact, she's telling the truth, that she did act in a fit of rage, that she got angry after her husband made that comment and she just snapped, leaving to Brazil, covering his body in a tarp, taking out money, does that also comply? Does that comport? And staying in that country in Brazil for 10 years, does that still comport with this theory?
I think so. I think that's why everything is going to be such a hair-splitting topic. Like, did she wire the money because she was killing herself, or did she wire the money because she needed to? Did she say on the plane, I should get 30 years, or I could get 30 years? Everything's going to really come down to, was it premeditated or was it a heat of passion?
And there's no real direct evidence of a self-defense claim. She at one point said that her husband had pushed her up against the wall, but even if that's the case, that wouldn't support the use of a firearm.
No, because right, it's not a self-defense, it's a heat of passion. So that's basically saying that she lost all control. But she bought the gun earlier, she researched things, I think she had a laser scope put on it, and this is all premeditated. She wired the money out, she knew what was going to happen.
We thought that at one point they were going to go with a battered woman syndrome, and maybe for our viewers you can explain a little bit what that is, but they had trouble getting experts on the stand to testify to that.
And I would think so. That goes more towards premeditation. Battered women syndrome is that over a long period of time, the ups and downs of a domestic violence relationship causes people to lose a sense of sort of reality when it comes to violence. They get trained to accept violence, so it becomes part of natural life. But here, you would need to have somebody who testifies that there's been a long-standing history of abuse, and they probably didn't have that.
Yeah, and without that, you don't have anything.
There's no battered women syndrome.
And even if you had battered women syndrome, is that, is that saying to the jury you must find her not guilty or guilty of a lesser charge?
It could be either one. But what it would at least do is it lengthens the time of the heat of passion. It doesn't have to be he said this, she got crazy, and she shot him. It could be she's been battered for so many years that it was building and building and then exploded on this day. So it gives her a much better defense to either heat of passion or manslaughter.
And listen, we're all trying to figure out what happened 11 years ago. This is a very unique case. Trial attorney Brad Micklin, thanks so much for coming on. We appreciate it.
Thanks for having me.
Have a great weekend. Now, listen, here's what we're going to do. We are going to take a break. When we come back, we're either going to be live in the Claudia Herod case. We're going to be recapping it. We'll also have other live trials we're focusing on. We're in Verdict Watch in New Jersey. There's a lot happening here on Friday right before we go to the weekend. So you know what I'm going to say? Stay tuned here on Law and Crime. We'll be right back